Absolutely. So the first step in any sort of eviction would be a notice that the tenant would receive. And under Louisiana law, the landlord has to give a 5-day notice, a minimal 5-day notice to vacate, letting the tenant know why they want them out. And it could just be the owner wants the property back. It doesn't have to. Even
if there's a lease that says it's a 6-month or a 1-year lease?
If there is a lease term, then the owner can't just have no cause and remove somebody during the lease term. But if the tenant hasn't paid rent, if there's any sort of dispute between the landlord-tenant, if there's a pet there that's not supposed to be there, the landlord can bring the action. And so the first step would be a written notice. Okay. This written notice doesn't have to come from the constable's office. It doesn't have to come from an attorney. It could be written on the back of a napkin. And
they put it in, tack it on your door, or how do they give you the notice?
They can tack it on your door, they can mail it to you, they can hand it to you. The tacking is okay, and a lot of people think, oh, I just got this notice on my door, it's not on an official document paper.
Doesn't matter.
It still counts as the notice.
The fact of the matter is, it has to be a written notice. Your landlord can't just say, I want you out of here. He or she will post some sort of notice.
That's correct.
Mm-hmm.
Okay, and if you get that written notice,
then
if
what?
you're the tenant, what are your rights? What can you do?
That notice gives you a period to let you know that the landlord wants you out. We recommend to always try to talk to your landlord and try to work it out. If you owe them money, try to work out a payment plan. If it's an issue with a pet, just try to talk it over, see if there's any way to repair that landlord-tenant relationship. Because during that 5 days, they can't actually come in and remove your items or change the locks or do anything like that. After that 5-day period is up, the landlord can then file in court for an eviction, which is called a rule of possession.
Yeah, well, and if I might add, just reiterating, when you get that notice, that's a really good time for you to read that lease again.
Right.
Because you will frequently find out, often even to the landlord's surprise, that if they obtained a lease from Home Depot or from MrLandlord.com or some website like that, there may be protections in there that are modeled off of another state, which may require things like a right to cure if it's a lease violation, or it may require a cease and desist notice. Or the holy grail for us is if we happen to see a mediation or arbitration clause. And so when you get that notice, that is really the time that if you do have a written lease, check it out, or have a lawyer check it out. The next step in the eviction process after the notice goes out is the landlord filing what's called a rule for possession, where they rule you into court. And that's where the landlord has to prove their case. The landlord has the duty to prove whatever they're alleging. Occasionally, just as a word to the wise, if you have a written lease, that first 5-day notice we mentioned, it can be waived. So you really want to check that out. If you have a waiver of that notice, it can make the process happen in a week or less. Typically, it takes 2 to 2.5 weeks to do an eviction if it's for cause. When you go to court, which is step 3, the judge is going to hear the evidence, and it's really, really important when you're in court, bring your evidence. I mean, you hear all these folks in court talking about, oh, well, I have that written down, or I have that receipt, but if you don't have it with you, it's like it doesn't exist. It doesn't. Sometimes you make out better if you have an attorney with you, so you can always contact us if you think you might be eligible for our services. And
go to the website, even if you're not. You'll get some good practical tips. And go to the show website, because we're putting a lot of the helpful to-dos on the show, the Power of Attorney website.
And then the last thing I would mention, if you do not have an answer filed, like a legal pleading filed in response to the landlord's eviction, if you lose the case as a tenant, the judges typically provide 24 to 48 hours. So it's extremely quick, and a lot of folks are kind of surprised how rapidly it moves. So, from start to finish, you're talking a couple of weeks.
You said an answer file? An answer file, which is?
An answer filed. It's just a written document where you're stating, this is why I shouldn't be forced to move, and you have to have it sworn under oath and notarized, and so it is a little difficult to do on your own.
Okay, yeah, and some of these cases can get to be very complicated. I would imagine, especially when you get into the subsidized housing issue, right?
Yes.
Yeah. Okay.